Hey guys, Dr. Scott here. Welcome to Week 2, Chapter 3. We're going to be discussing the legal context of employment decisions. I apologize in advance for not getting you guys Chapter 2. I had problems uploading it. Every time I attempted to, it either told me there was not enough space, I didn't have permission. So when we get back next week and the school's open, I'm going to send the file over to our IT guys and let them figure out what the problem is. Anyways, I hope you're having a good weekend. I've been home with an infant who has a middle ear infection. We ran him to the ER last night. He kept spiking a temp of 102, 103. Doctor looked at him and said, "Oh yeah, he's got an ear infection and it's bad." So we got him on a Z-Pack, over-the-counter Tylenol. You know, he's little, so we can't keep pumping him full of it. But he's making progress. We're at least getting more sleep now. But we are set up for a consult with our ear, nose, and throat guy, and I'm just going to say, look, I don't care what you say, put tubes in his ears so we can all get on with our lives. So that's kind of what I'm looking forward to in the next week or so. On another note, my 3-year-old decided to come down with conjunctivitis this weekend, so he's got this junk coming out of his eyes and his nose, and I've been using the neti pot, and it's been a fun Memorial Day weekend. If you have kids, you pretty much can sympathize or empathize that when they're going to get sick, it's going to be on a holiday weekend when your doctor's out of town and the only thing that's open is your local ER because the clinics were closed and everything. So if I apologize for having the beard and all that, it's just I have not had a chance to grab much sleep lately because I've been on call with the police department and doing everything else. Anyways, back to reality here. This week we're going to hit Chapter 3. Like I said, it's the legal context of employment decisions. During this week, we're going to answer 5 questions. All right, I'm reading this off my notes here. How are employment practices affected by the civil rights laws and Supreme Court interpretations of those laws? What should be the components of an effective policy to prevent sexual harassment? Even though you guys roll your eyes and you sleep through those sexual harassment trainings or those annual trainings or quarterly trainings you get on sexual harassment, very well alive right now. It's very important that we understand what sexual harassment is in the workplace, the way it's changing now. It's not just the quid pro quo, but we also have to think about emails, Facebook. We have to think about social media, stuff that's being said or insinuated or perceived in the workplace to avoid a sexual harassment allegation, complaint, or lawsuit. What obligations does the Family Medical Leave Act impose on employers, FMLA? What rights does it grant to employees? When a company is in the process of downsizing, what strategies can it use to avoid complaints of age discrimination? Older people or more senior people want to work longer, all right? Or if you're promoting someone who's been there, who's got tenure, versus someone who might be relatively new, much younger, and has a degree, do you have an age discrimination lawsuit? So we'll talk about some of that. What should senior management do to ensure that job applicants or employees with disabilities receive what we call reasonable accommodations? This is a big chapter, all right? This is more or less the nuts and bolts of what we face in human resource management today, or at least in 2015. Now, the big question we're dealing with right now is retaliation, okay? And that's the new legal standard of some preventative measures. According to the U.S. Equal Opportunity Employment Commission, the EEOC, an employer may not fire, demote, harass, or otherwise retaliate against an individual for filing a charge of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination, meaning that they should have the right, if it's legitimate, to come forward and file a complaint or be a party to a complaint and not fear any reciprocity from the employer or from their boss or from the company that they filed the suit with or into their internal investigations. Now, the same laws that prohibit discrimination based on race, color, sex, religion, national origin, age, and disability, as well as wage differences between men and women performing substantially equal work, also prohibit retaliation against individuals who oppose unlawful discrimination or participate in an employment discrimination proceeding, meaning that your employees, you as an employee, or if you're overseeing or supervising employees, are protected. Now, prior to the recent U.S. Supreme Court decision, case law had defined retaliation largely meaning as a loss of a job. The court's ruling in Burlington North versus the Santa Fe Railroad Company and versus White expanded the definition of employer retaliation, making it easier for employees to file such claims. Workers can file retaliation suits even when an employment action does not diminish their pay, hours, or benefits or cause them to suffer any monetary loss of any kind. Anti-retaliation laws potentially extends to an employer conduct even when it's not work-related. Now, the court that ruled each case will have to be evaluated on its own context. So what we have here is we have both sides of the coin being decided, saying, look, we need to have an open environment where you can file retaliation, or some kind of complaint, but basically not be afraid of losing your job, especially if there's something legitimate going on in the workplace. Furthermore, bosses who have to deal with these or those accused cannot retaliate simply by firing you, reducing your hours, modifying your job without cause, and probably without notice and hearing, which we'll talk about in a little bit. Now, the challenge questions we look at is what effects do you think this decision had on a number of retaliation charges filed with the EEOC? In the court's ruling in Burlington North and Santa Fe Railroad California versus White, this expanded the definition of employee retaliation, making it easier for employees to file such claims. Specifically, the ruling allows workers to file retaliation suits even when the employment action does not diminish their pay, hours, or benefits or cause them to suffer any monetary loss of any kind. However, or moreover, anti-retaliation laws potentially extends to any employer conduct even when it's not work-related. You create a hostile work environment. You surpass someone or pick someone else for a promotion or for a job. You demote them, but you keep them at the same pay. You either add on or take away their duties. It's almost like you're walking a very fine line here. The court further ruled that the sweep of the anti-retaliation law extends to any employer conduct, even when it's not work-related, that is severe enough to deter a reasonable employee from exercising her legal right to object to discrimination. So the question that comes to bear is what can an employer do to avoid liability for retaliation? The best way to avoid liability for retaliation is to prevent it from ever happening. 2 management actions can help. Add an anti-retaliation policy or update an existing one, and provide specific training to supervisors on retaliation using the BNSFS versus White, the court case, to explain what might constitute retaliation. Meaning that you as a supervisor, you as a boss, it is incumbent upon you to train your employees or to go to your boss and say, hey, what is our current anti-retaliation clause or our training? Most of them will shrug their shoulders and say, I don't know, go ask my boss, or we don't have one. Now you have the knowledge to know that, hey, we probably need to have this in the workplace. Now, following this ruling, what changes in a company policies might be necessary? Experts recommend that an anti-retaliation policy include the 5 following elements. Number 1, a clear statement that, like discrimination and harassment, retaliation is prohibited by both law and company policy, and that the retaliatory acts will lead to discipline and/or discharge. Second, a brief illustration of types of conduct that might be prohibited by the policy. Third, you have a mechanism for reporting possible acts of retaliation. Fourth, a statement that complaints will be properly investigated and resolved as appropriate. And then 5, and this is most important, is that a statement that complaints will be maintained as confidential to the extent practicable, given the need to investigate and resolve issues. If there has to be some anonymity, that must be first and foremost to preserve the integrity of the complainant as well as probably the investigation as it gets underway. So some of the societal objectives we look at, that there's a broad goal of society that is to provide all Americans, regardless of race, age, gender, religion, national origin, or disability, an equal opportunity to compete for jobs for which they're qualified. For Americans with disabilities, the nation's goals are to ensure equality of opportunity, full participation, independent living, and economic self-sufficiency. Whenever the members of heterogeneous groups must work together, the possibility of unfair discrimination exists. There's always going to be people who want to be mainstream, but for whatever reason, they lack the qualifications, they lack the experience. There might be a disability or physical ailment that prohibits them from doing the job necessary. Therefore, the equal opportunity and unfair discrimination comes into play, and this is what they are. Number 1, there's civil rights laws, judicial interpretations of laws, and many state and federal guidelines that have outlined discrimination based on race, religion, national origin, age, sex, and physical disability. No laws have ever precisely defined the term discrimination. That's very important. In the context of employment, it can be viewed as the giving of an unfair advantage or disadvantage to the members of a particular group in comparison with the members of other groups. The disadvantage usually results in the denial or restriction of employment opportunities or an inequality in the terms or benefits of employment. If there are more candidates than available positions, some candidates must be excluded. If the exclusion is based on job-related criteria, it is entirely proper. Hi, that's my wife, Marla. Hi, she's helping. EEO implies that there must be at least two things. I'm sorry, she just put the kids to bed. Number one, the evaluation of candidates for jobs in terms of characteristics that really do make difference between success and failure. Failure and equal treatment of employees on the job. Therefore, discrimination is a subtle and complex phenomenon that assumes two broad forms: unequal or disparate treatment. This cases that rely on direct evidence of the intention to discriminate: male, female, sexual orientation, religious backgrounds. Now, political affiliations could fall into this category. Cases that are proved through circumstantial evidence of the intention to discriminate. Then we have what we call mixed motive cases that rely on both. You also have to remember, in the workplace, and I'm going to go out on a limb here, this is not beyond a reasonable doubt. This is going to be a preponderance of the evidence, which is just 51% of the vote of evidence to persuade a person or a panel of individuals that discrimination exists or continues to exist in a particular situation in a job. Now, the adverse impact, what we call the unintentional discrimination. Now, this occurs when identical standards or procedures are applied to everyone, all right, despite the fact that they have led to a substantial difference in employment outcomes for members of a particular group, and they're unrelated to the success on a job. So we talk about the legal context of human resource decisions, going back to why we're studying this in the class. Well, the federal employment laws fall into two broad categories. That's two. The law of broad scope that prohibited unfair discrimination is the first. The second is the law of limited application. For example, those that require non-discrimination as a condition for receiving federal funds or contracts. Now, the law of broad scope basically focuses on the 13th and 14th Amendments. The Civil Rights Acts of 1866 and 1871 is where it got started. Then we moved into the Equal Pay Act of 1963, meaning that everyone should have equal pay regardless of gender, regardless of race, regardless of creed or religious background. Then we created the Title VII of the Civil Rights Act a year later in 1964. Then we had the Civil Rights Act of 1991. Then we looked back and we looked at age discrimination for a moment. We had the age discrimination in employment. Hi, this is my son Mark. Come say hi. I'm talking to my class.
Hi.
All right, go to bed. Give me a kiss. Bye. Good night. All right, that's his moment of fame. We looked at the age discrimination in employment of 1967, and then it was later amended almost 20 years later in 1986. And then we look at lately the Immigration Reform and Control Act of 1986. We look at how immigration is actually working its way into the workplace now. Immigration is a hot topic in 2015. We look at the American with Disabilities Act of 1990, and then it was amended in 2008. And of course, all of us probably are more familiar with this, which is the Family Medical Leave Act, in which we can leave our job for certain periods of time when we're adopting a baby or having a child by natural childbirth. You can basically leave your job for 2 to 6 weeks or 12 weeks, depending if there's complications or not, and you don't have to worry about having your job replaced, being demoted, or moved around in your absence. All right. Also, with the death of a family, or if a family becomes to the point where they need your constant care, you can take so much time off to tend to them with the promise you're going to return to work. We have laws of limited application under the federal government, Executive Orders 11246, 113075, and 11478. We have the Rehabilitation Act. We also have federal acts that require the Vietnam Era Veterans Readjustment Act. That was a work study or a work-provided program helping veterans from Vietnam who were returning get into the workforce so they couldn't be discriminated upon. Uniformed Services Employment and Reemployment Rights Act of 1994. Now, earlier I mentioned the two big amendments, the 13th and 14th Amendments. The 13th Amendment prohibits slavery and involuntary servitude. We had that when we repealed slavery. However, if you think about it today in 2015, what about human trafficking? All right, that's a hot topic right now in law enforcement. All right, we have all kinds of training for human trafficking. And when I say human trafficking, most people focus on sex commercial acts, prostitution, child pornography, brothels, massage parlors. But another section of this is going to be forced labor. Those are the people that are building your buildings, your schools, your roads, your duplexes, your subdivisions, who come over here illegally. Now they're not smuggled, but they're trafficked over here, and they're basically paying off a debt, 2 or 3 cents on the dollar with like 200% interest, meaning that they're never in their lifetime going to be able to pay off what they owe to the people that traffic them over here. But they're forced to live in an apartment with 20 or 12 guys. They're forced to work under extreme hard conditions. All right, it's alive and well in East Texas. It's alive and well in all 50 states. But that would fall under the category of the 13th Amendment. Now, the 14th Amendment guarantees equal protection of the law for all citizens. When you file a class action lawsuit in law enforcement, for example, you're going to file it under violation of the 14th Amendment. When you're a citizen and you think a police department has used excessive force or wrongful death suit, is typically going to fall under 83 case, which is the U.S. Code, U.S. 1983, which is a violation of the 14th Amendment. Now, we looked earlier at the Civil Rights Acts of 1866 and 1871. The Civil Rights Acts of 1866 grants all citizens the right to make and enforce contracts with employers. While this law relates primarily to racial discrimination and the right of making enforcement of contracts, it also provides a federal remedy against racial discrimination in private employment. It covers both large and small employers, even with those fewer than 15 employees. In a unanimous decision by the Supreme Court, they ruled that race was equated with ethnicity, rather than skin pigment. Therefore, Arabs, Jews, and other ethnic groups thought as white was not barred from suing under the Act. During the Civil Rights Act of 1871, this also granted all citizens with the right to sue in federal court if they feel that they have been deprived of any rights or privileges guaranteed by the Constitution or other laws. Now, fast forwarding almost 100 years later, the Equal Pay Act of 1963. This act was an amendment to the Fair Labor Standards Act of 1938, which requires that men and women working with the same establishment be paid the same rate of pay for the work that is substantially equal in skill, effort, responsibility, and working conditions. Pay differentials are legal if they are based on seniority, merit, systems that measure the quality, quantity of work, and any factors other than sex. You guys got to remember, prior to the 1960s, women and men worked in different classes. You didn't see a whole lot of women in the workforce. In correcting the inequality of under the Equal Pay Act, employers must raise the rate of lower-paid employees and not lower the rate of higher-paid employees, meaning that higher-paid employees stayed right where they were. We just had to bring the salary up for the lower-paid employees. Now, the Title VII and Civil Rights Acts of 1964, this was a significant game changer, all right, in terms of human resource management. This act is divided into several sections or titles, each dealing with a particular facet of discrimination. Title VII is the most relevant to employment because it prohibits discrimination on the basis of race, color, religion, sex, national origin, and all aspects of employment. The Equal Opportunity Commission, that EEOC that I mentioned earlier, was created to ensure that employers, employment agencies, and labor organizations comply with Title VII. The law was passed to guarantee that people would be considered for jobs on the basis of their abilities and talents that are necessary to perform that job, or a job. This law includes almost all public and private employers with 15 or more employees except private clubs, religious organizations, and places of employment connected with Indian reservation because they are federally protected. In 1972, the amendments that also prohibited the denial, termination, or suspension of government contracts without a hearing of an employer has followed. It is now following an affirmative action plan accepted by the federal government for the same facility within the prior 12 months. The term affirmative action, you guys have heard this. Affirmative action refers to those actions appropriate to overcome the efforts of past and present policy, practices, and other barriers to equal employment opportunity. Back pay awards are limited to 2 years, all right, to the filing of a charge. The 2-year statute of limitation begins with the filing of a charge of discrimination, meaning if you feel that you've been a victim of this, you can go back from the day you filed to 2 years to the date to recover your funds or lost wages. Now, all the following are exempted from Title VII coverage. What we call BFOQs, the bona fide occupational qualifications, seniority systems, pre-employment inquiries, testing, preferential treatment, and national security. Those are going to be exempted from being filed under Title VII. Now, how these are litigated claims under unfair discrimination. If someone decides to bring a suit under Title VII, the first step is to establish a prima facie case of discrimination. When we say prima facie case, we mean on the face of the case itself. We're just looking at the facts of it, which is usually presented either through direct evidence of the intention to discriminate or by circumstantial evidence. Again, we're looking at preponderance of the evidence and not beyond reasonable doubt, like in law enforcement or laws cases. The legal standard for circumstantial evidence is a 4-part test, wherein the plaintiff must be able to demonstrate 4 things. She or he is asserted on a basis protected by Title VII that age discrimination in employment and the Awareness of the American Disabilities Act. She is somehow harmed or disadvantaged. He or she is qualified to do the job or perform the job in a satisfactory manner. Either the similarly situated individual or group was treated more favorably than the plaintiff, or the matter complained of involved in the actual employment opportunity. Now, once the court accepts the prima facie evidence, the burden of producing evidence shifts back and forth from the plaintiff to the defendant. This is going to be a civil hearing, okay? This isn't going to be you're going to have a prosecutor and a defendant, not the jury trials you're used to seeing like on Law & Order or CSI. This is going to be a civil matter. Now, the Civil Rights Act of 1991, this act overturned 6 Supreme Court decisions issued in 1989. The following are key provisions that are more likely to have the greatest impact in the context of employment. Number 1 is monetary damages in jury trials. Victims of intentional discrimination can ask for compensatory damages for pain and suffering as well as for punitive damages, but only from non-public employers. Victims may demand a jury trial, meaning that instead of having a judge or an arbitrator decide, you can have a jury of your peers in a civil case, listen to the facts of the case, and have a jury render a verdict. Damages may not be awarded in the Americans with Disabilities Act case when an employer has engaged in good faith efforts to provide reasonable accommodations, meaning that if someone who does have a disability, they're still not performing or they feel that they've been treated unfairly, and it goes to show, again, prima facie evidence that the employer has gone to every length possible to make every necessary accommodation for this individual, and they're still not performing or they're not able to do the job or unwilling to do the job, and they terminate them, they can pretty much show in court that they have done everything humanly possible to accommodate this person and under good faith let them go or terminated them. Chances are that case will not see the light of court. The following key provisions are more likely to have the greatest impact on the context of employment, like I said earlier. The total amount of damages, go back here, the total amount of damages that can be awarded depends on the size of the employee's workforce, all right? It can go anywhere from $500,000 to $300,000, excuse me, $50,000 to $300,000. However, I can tell you probably there'll be more depending on the size of the company. If you get somebody like Apple, BP, JP Morgan, Johnson & Johnson, for example, or a big city like Los Angeles, Dallas, Houston, New York, or something like that, and it's a good case that goes to a jury and they award damages, chances are you could probably see close to millions or $500,000. A good case here in Colstead versus the American Dental Association. The Supreme Court held that the availability of punitive damages depends on the motive for the discriminator rather than the nature of the conduct, the extent to which the egregious or if it was egregious or outrageous. Now, earlier I discussed adverse impact, that unintentional discrimination case. The Act clarifies the parties' obligations in such cases. We look at for the protection of discrimination and employment is extended to U.S. citizens employed in a foreign facility that's owned and operated by the U.S. company, your oil companies, for example. All right, those that are teaching overseas, those that are doing work for, say, BP or Apple, or they're overseeing a plant, say, in Hong Kong or Dubai or something like that. Because it's American-owned, the discrimination cases that are filed, even though they're on foreign soil, will still hold up because they're under the umbrella of an American organization or company. However, the employer does not have to comply with the U.S. discrimination law if they do so would violate the law of the foreign country. So again, there's that catch-22. What was the act? What happened? And does it meet the merits to stand in court? Now, another thing we need to consider is racial harassment. The act amended the Civil Rights Act of 1866 so that workers are protected from intentional discrimination in all aspects of employment, not just hiring and promotion. Challenges to consent decrees. Once a court order or consent decree is entered to resolve a lawsuit, non-parties to the original lawsuit cannot challenge such enforcement actions. Meaning you can't have a bunch of people jumping on the bandwagon thinking that they're going to get a check or some kind of change from the outcome of the case. Now, in a mixed motive case, an employment decision was based on a combination of job-related factors as well as the unlawful factors such as race, gender, religion, or disability. In a recent decision by the Supreme Court, they ruled that the plaintiff must prove that, but for his age, the adverse action would not have occurred. We've had cases like that. If you look at religion, if you have like predominantly an all, Baptist or Pentecostal organization, and you have people promoting, and then you have someone, say, who's from Jewish, Muslim, Catholic, or something, who's outside, who has just as many or more qualifications that are constantly being passed over or given menial assignments compared to the coworkers, they might have a case to file a grievance on. Now, we look at seniority systems. This is something I mentioned I'm not a big fan of, but a seniority system that intentionally discriminates against the members of a protected group can be challenged within 180 days at any of the 3 points. When the system is adopted, when the individual becomes subject to the system, and when the person is injured by the system, we can basically bring a case. But remember, it's got to be within 6 months. Now, racing, norming, and affirmative action. The Act makes it unlawful to adjust the scores, use different cutoff scores for, or otherwise alter the results of employment-related tests on the basis of race, color, religion, sex, or national origin. Under race norming, each individual's percentile score on the selection of tests was computed relatively to others in his or her race, ethnic group, and not relative to the scores of all persons who took the test. If you guys remember, during the 80s and 90s, there was this big push to bring women or females into the workplace as well as people from other ethnic backgrounds. Simply because you were a female or because you were a particular ethnicity, and it would say something similar to a civil service exam, you might have automatically been given 5, 10, or 15 additional points simply because of your upbringing, your background, your gender, your ethnicity. The Supreme Court came in and said, no, that's not fair, because it's almost like reverse discrimination when it came to hiring people. Now, the extension to U.S. Senate and appointed officials. This act extends protection for discrimination on the basis of race, color, religion, gender, national origin, age, disability to employees of the U.S. Senate, political employees of the President, and staff members employed by elected officials at the state level. Now, how the age discrimination works, what we call ADEA, it started in 1967. And as amended in 1986, this act prohibits discrimination in pay, benefits, or continued employment for employees aged 40 or over unless an employer can demonstrate that the age is a BFOQ for their job in question. The key objective of the law is to prevent financially troubled companies from singling out older employees where there are cutbacks. Older workers ages 40 or over can waive their rights to sue under this law. Now, you look at this, you think about the federal government, for example. They have a mandatory retirement age. If you're trying to become, say, a federal agent with the FBI, CIA, U.S. Marshals, Secret Service, whatever, typically that's a status 1811 position, and the mandatory cutoff age is you have to be working full-time by them by the age your birthday turns 37. All right, so that way they can get you out by age 57. Sometimes if you've got veterans points or former military, or you're doing a lateral move into this organization from somewhere else, then they can let you in and they can grandfather you in. Now, moving on to a more current topic, we talk about immigration reform in the Control Act of 1986, or what we call IRCA. That's Immigration Reform and Control Act. This applies to every employer in the United States. It also applies to every employee, whether full-time, part-time, temporary, or seasonal. The basic features of the law fall into three broad categories. Employers may not hire or continue to employ unauthorized aliens. Employers must verify the identity and work authorization of every new employee. Employers with 4 to 14 employees may not discriminate on the basis of citizenship or national origin. Failure to comply with verification rules can result in fines from $100 to $1,000 for each employee whose identity and work authorizations have not been verified. I can tell you from experience that most businesses will pay the fines. If they have just like 20 or 30 employees that are doing great work and they're not here legally and they're making millions of dollars, these little fines mean nothing to them. They will gladly write a check, they'll gladly pay it in cash, and they'll continue to do business until the government has more teeth to do something to them. Now, this act also provides criminal sanctions from employers who engage in a pattern of practice of violations, and the 1996 order executive prohibits companies that knowingly hire illegal aliens from receiving federal contracts. There's the bite. If you have, say, Lockheed Martin or NASA or a company that works for the government, like a military contractor or someone that builds something, and they're receiving federal dollars, if it becomes knowledge that they're hiring illegal aliens, they will lose those federal contracts in theory. Now we go back to the American Disabilities Act, the ADA. This applies to all employers with 15 or more employees. Under it, people with disabilities are protected from discrimination in employment, transportation, or public accommodation. A qualified individual is one who is able to perform the essential functions of a job with or without accommodations. Disability is a physical or mental impairment that substantially limits one or more major life activities, such as walking, talking, seeing, hearing, or learning. Very important that you guys know that. Let me read it again. Disability is a physical or mental impairment that substantially limits one or more major life activities, such as walking, talking, seeing, hearing, or learning. Rehabilitated drug and alcohol abusers are also protected, but current drug abusers may be fired. The alcoholic, in contrast, is covered and must be reasonably accommodated by being given a firm choice to rehabilitate himself or herself or face career-threatening consequences. The law also protects people who have been tested positive for the AIDS virus or HIV virus. The ADA Amendment of 2008, or the Act of 2008, overturned 2 Supreme Court case decisions that interpreted the ADA's definition of disability narrowly and broadening the definition of a disability by expanding the terms of major life activities. As a result, the focus of employers is less of what constitutes an ADA disability and more on what constitutes reasonable accommodations. Employers are not just required to lower work standards and tolerate misconduct or give someone a make-work job. Now, there are 5 important implications for employers. Any factory, office, retail store, bank, hotel, or other building open to the public must be made accessible to those with physical disabilities. Expense is no excuse, unless such modification will lead an employer to suffer undue hardship. Considering the cost of accommodation, the employer's size, financial resources, and the nature and structure of its operation. Most public buildings now, most organizations have disability parking, have a ramp where they can get in, have that button where you can push the doors open automatically. Employers must also make reasonable accommodations for qualified job applicants or employees with disabilities. 5 strategies for improving employment opportunities with people with disabilities is you partner with public and private disability agents and community organizations. You provide information and outreach. You mandate increased awareness and education. You use technology to redesign jobs and establish pipelines to reach school-age recruits with disabilities. You also have pre-employment physicals will now be permissible only if the employees are subject to them, and they cannot be given until after the conditional offer of employment is made. Medical information on employees must be kept separate from all personal and work-related information about them. Drug testing remains intact, though. An employer can still prohibit the use of alcohol and illegal drugs at the workplace and continue to give alcohol and drug tests. Most companies do random drug tests. They'll pull you in once every quarter or half a year and say, hey, go down to the lab, go pee in a cup, and see if you're on anything and test you for alcohol randomly. Trained supervisors, HR professionals, and anyone else who supervises employees, interviews candidates, or make hiring decisions. Really, it's going to be a matter of convenience and cost. and not in that order when you start doing these random drug tests. And the enforcement we have, the EEOC enforces the American Disabilities Act. Individuals with disabilities may be awarded both compensatory and punitive damages up to $300,000 if it can be shown that the employer engaged in discriminatory practices with malice or with reckless indifference. Okay, so shifting gears here just for a minute, the Family Medical Leave Act is kind of what I'm going to talk about here for just a second. And this is a big section. It talks about quite a bit here, okay, and I'm just making sure I don't forget anything here. All right, FMLA. Get back up here. Many of you guys understand what FMLA is. You got it when you were hired or you use it periodically. But what I'm going to do is kind of give you the nuts and bolts of FMLA. It started in 1993. Now, FMLA is the Family and Medical Leave Act, and it covers all private sector employers with 50 or more employees, including part-timers who work 1,250 hours over a 12-month period, an average of 25 hours per week. The law gives workers up to 12 weeks of unpaid leave each year for birth, adoption, or foster care of a child within a year of the child's arrival, care for a spouse, parent, or child with a serious health condition, or the employee's own serious health condition if it prevents him or her from working. Employees can require to provide medical certification of such illnesses and can require a second medical opinion. Employers can exempt from the FMLA key salaried employees who are among the highest paid 10%. For leave takers, employers must maintain health insurance benefits and give the workers their previous job or comparable positions when their leave time is over. The overall impact of this law was softened considerably by the exemption of some of the fiercest opponents, companies with fewer than 50 employees, or 95% of all businesses in the United States. The FMLA was amended and expanded to include military families in 2008. Businesses are required to offer up to 26 weeks of unpaid leave to employees who provide care for wounded U.S. military personnel. Employers must also provide 12 weeks of FMLA leave to immediate family members of soldiers, reservists, or members of the National Guard who have qualifying exigency. Now, under the executive orders that I mentioned earlier, 11-246, 11-375, and 11-478, these are presidential executive orders, and they fall into the realm of employment, and discrimination are aimed at specifically federal agencies, contractors, and subcontractors. They have the force of law even though they are issued unilaterally by the President without congressional approval. To break it down, Executive Order 11-246 prohibits discrimination on the basis of race, color, religion, or national origin by federal agencies, contractors, and subcontractors with contracts of $10,000 or more. Executive Order 11-375 prohibits on the discrimination based on sex only. The Executive Order 11-478 prohibits the discrimination of employment based on all previous factors plus political affiliation, marital status, and physical disability. So these three executive orders at the federal level covers everything we've talked about specifically for federal employees. Now, Executive Order 11-246 also provides considerable enforcement power administered by the Department of Labor through the Office of Federal Contract Compliance Programs, which is the OFCCP. Under the finding of the OFCCP of noncompliance with the order, the Department of Justice, DOJ, may be advised to institute criminal proceedings, and the Secretary of Labor may cancel or suspend current contracts as well as the right to bid on future contracts. So not only will they have criminal charges potentially put on them, but the fact that you could lose bidding or contracts are in line to get million-dollar contracts could also hurt you financially. Now, under the Rehabilitation Act of 1973, this act requires federal contractors and subcontractors to actively recruit qualified people with disabilities and to use their talents to the fullest extent possible. The purpose of this act was to eliminate systemic discrimination within the workforce. The Vietnam-era Veterans Readjustment Act of 1974, federal contractors and subcontractors required under this act to take an affirmative action, proactively, to ensure equal employment opportunity for veteran-era veterans. We have the Uniformed Services Employment and Reemployment Rights Act of 1994. Regardless of the size of its organization, an employer may not deny a person initial employment, reemployment, promotion, or benefits based on the basis of that person's membership or potential membership in the U.S. or in the armed services. This act requires both public and private employers to promptly reemploy individuals returning from uniformed service in the position that they would have occupied with the seniority rights they would have enjoyed had they never left. Employers are also required to maintain health benefits for employees while they are away, but they are not required to make up the difference between military and civilian pay. That's good news for our military folks. Now, the federal enforcement agencies, the EEOC and OFCCP. The EEOC is an independent regulatory agency whose 5 commissioners are appointed by the President and confirmed by the Senate for a term of 5 years. That's 5, sorry. No more than 3 of the commissioners may be from the same political party. The EEOC sets policies and in individual cases determines whether there is reasonable cause to believe the unlawful discrimination has occurred. Once it receives a complaint of discrimination, the EEOC follows a 3-step process, which is investigation, conciliation, and litigation. Complaints must be filed within 180 days or 6 months of the alleged violation, 300 days if the basis of discrimination is prohibited by either state or local laws. The complaint has been referred to the state agency charged with EEOC enforcement for resolution within 60 days. If the complaint cannot be resolved within 60 days, the state agency can file suit in the state district court and then appeal any decision to the state appellate court, the state Supreme Court, or the U.S. Supreme Court. Alternatively, the state agency may defer to the EEOC. If the EEOC reaccepts the case, it will seek voluntary reconciliation. If this effort fails, the EEOC can refer the case to the Justice Department or file suit in federal district court. Like in state courts, decisions federal courts may be appealed to one of the 12 U.S. Court of Appeals and further to the U.S. Supreme Court. Now, under EEOC guidelines, they have issued a number of guidelines for Title VII compliance. Although these guidelines are not laws, the Supreme Court has indicated they are entitled to what they call great deference. When we talk about information gathering, for example, each organization in the United States with 100 or more employees must file an annual report, or what we call the EEO-1, detailing the number of employees by job category and then ethnicity, race, and gender. Through computerized analysis of the forms, the EEOC is able to identify broad patterns of discrimination, or what we call systemic discrimination, and to attack them through class actions. Now, the Office Contracts Compliance Programs, contract compliance simply means this. It means that contractors and subcontractors must meet EEO and affirmative action requirements. Contractors and subcontractors with more than $50,000 in government business and with 50 or more employees must prepare or implement written affirmative action plans, and they have to be on the books. In jobs where women and minorities are underrepresented in the workforce relative to their availability in the labor force, employers must establish goals and timetables for hiring and promotion. When a compliance review by the OFCCP indicates problems that cannot be resolved easily, it tries to reach conciliation agreement with the employer. Now, we have what we call in these circumstances affirmative action remedies. In 3 different cases, the Supreme Court found that Congress specifically endorsed the concept of non-victim specific racial hiring goals to achieve compliance. The court also noted that the benefits of flexible affirmative action plans. Therefore, employee case laws came into play. Although Congress enacts laws, the courts interpret the laws and determine how they will be enforced. Such interpretations define what they call case law, and you guys have heard this before. Case law, which serves as the precedent to guide future legal decisions, or what we call stare decisis, meaning let the decision stand. Precedents are regularly subject to interpretation. In the area of employment, considerable body of case law accumulated since 1964 during the Civil Rights era. On the basis of sexual discrimination, for example, the Supreme Court ruled that traditionally sex-segregated jobs, a qualified woman can be promoted over a marginally better qualified man to promote more balanced representation. The court also expressed disapproval of the strict numerical quotas except when necessary on a temporary basis to remedy severe past discrimination. Ladies, in terms of pregnancy, the EEOC guidelines for the Pregnancy Discrimination Act of 1978 state a written or unwritten employment policy or practice which excludes from employment applicants or employees because of pregnancy, childbirth, or relative medical condition is prima facie evidence that violates the Title VII. Under the law, an employer is not required to give pregnant employees special treatment. The length of maternity leave is to be determined by the woman and/or company's physician. Many employers are doing the best they can to accommodate pregnant women through flexible working schedules and generous maternity leave policies. To give you an example, years ago in my department, we had several female officers that were getting pregnant, and our Pat, I think it was like 3 or 4 chiefs ago, they weren't sure if they had to pull them off the streets, make special accommodations. Some of them wanted to send them home for the duration of their pregnancy. This went up as high as it could, or higher, in my opinion, than it needed to. And they basically said it was up to that female officer on a case-by-case basis to determine when he or she was unfit or unable to, I'm not going to say unfit, unable to do their duties on patrol, for example. By then, they would come into the department and we'd have to reassign them either to, say, CID, records, some kind of non-patrol division, but they would keep their hours, keep their pay up until, their water broke and they'd have to go deliver, and then they'd be out for 12 weeks. To me, in my mind, this made sense. I mean, you don't just send someone home because they're pregnant. It's not an illness. They chose to do this, to have a baby and to engage in the miracle of life. Therefore, I think it's incumbent upon any job to have a policy in place saying, look, the minute you are obviously showing you can't chase the bad guy, you can't fit into your uniform, you can't, more importantly, wear your protective vest, then we got to bring you in and modify your job and reassign you. Now, many employers, like I said, are doing their best to accommodate them through flexible work schedules, generous maternity leave policies. I think most employers just want a heads up, and they talk to the employee, and I think, like, at least in my perception, I could be dead wrong. I can't speak for every company, but I would like to think that they have kind of a game plan in place on a case-by-case basis when that particular worker knows that she can't work or has to have her job modified or something like that, and they have a physician backing them up. It shouldn't be a big deal. Now, reproductive hazards. Sexual discrimination may be perpetuated by barring women from competing for jobs that pose occupational health hazards to the reproductive systems. In the UAW versus Johnson Controls, Inc., the Supreme Court ruled that decisions about the welfare of future children must be left to the parents who conceive, bear, support, or raise them, rather than to the employers who hire those parents. The Supreme Court noted that it would be difficult to sue a company for negligence after it abandoned its fetal protection policy if the employer fully informs women of the risk and it has not acted negligently. Women are no more sensitive to reproductive hazards than are men. Now we'll go back to my favorite here, sexual harassment, which we've all had every time you get a job. You get some kind of training or you get someone explaining what and how sexual harassment works in the workplace. Sexual harassment is not really about sex. Let's talk about that. It's more about power. Power and control, to be specific. In the vast majority of cases on this issue, females rather than men have suffered from sexual abuse at work. The clearest definition is provided by the EEOC as the unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. The no-frills definition can be put into one word, and that is unwelcome. According to the courts, for behavior to be treated as sexual harassment, the offender has to know the behavior is unwelcome. If a person wants to file a grievance, it is important to be able to prove either that he or she told the perpetrator to back off, or that action was so offensive the harasser should have known it was unwelcome. Now, there are 2 types of sexual harassment. First is the quid pro quo. All right, quid pro quo exists when the harassment is a condition of employment. You give me this, I'll give you that. Hostile work environment is the second. Hostile work environment includes verbal or physical conduct that creates an intimidating, hostile, or offensive work environment and interferes with the employee's job performance. Now, employers are always potentially liable for the supervisor's sexual misconduct toward an employee, even if they knew nothing about the supervisor's conduct. Again, you got to remember that if this is going to happen, it's going to file under a Section 83 case, or what we call a Title VII under the 14th Amendment. So you've got to remember that just because you didn't know, that's not going to make you, exempt from being sued. Employers are always potentially liable. Let me read it again. For the supervisor's sexual misconduct toward an employee, even if they knew nothing about the supervisor's conduct. Now, with regards to the Civil Rights Act of 1991, this permits victims of sexual harassment to collect a wide range of punitive damages and attorney's fees from the employers who mishandle the complaint. An employer has no defense when a supervisor harasses an employee or an adverse employee action, an employment action results. In a hostile work environment cases, however, the employer may avoid liability if it can be proven that it exercised reasonable care to prevent and promptly correct any sexual harassment of behavior, and the plaintiff failed to use any preventative or correction methods provided by the employer. What I take away from this, from personal experience as a supervisor and a shift supervisor and training guys in liability, is you better know what your employees are doing. You come out of the office, you talk to them, you have literally that open door policy, meaning that you have in policy something that says how you will take complaints and, more importantly, how you're going to investigate them and give them a best guess time method, hopefully immediate, in investigating these complaints. This will absolve you from some of the possibility of being sued down the road. Now, preventative actions by employers. To escape or at least limit its liability for sexual harassment or sexual harassing acts of its employees, a company should have an anti-discrimination policy that includes these features. A statement from the CEO that states firmly that sexual harassment will not be tolerated. Put it in bold, underline it right off the bat. A workable definition of sexual harassment that is publicized via staff meetings, bulletin boards, handbooks, and new employee orientation programs. Create an effective complaint procedure that includes multiple ways to file the complaint. A clear statement of sanctions for violators and protection for those who make charges. Prompt confidential investigations of every claim of harassment, no matter how trivial it may seem. You investigate it. You give a disposition on it. Preservation of all investigative information with records of all such complaints kept in a central location, and it's confidential. Take care of it. Regular training of all managers and supervisors to model appropriate behavior and to recognize and respond to complaints. And then you have the follow-up to determine if harassment is stopped. It's incumbent upon you as the boss to go back and make sure that this nonsense is knocked off and it's not repeating itself or it's been swept under the carpet. Now, shifting gears from sexual discrimination to age discrimination, the EEOC guidelines on age discrimination emphasize that in order to defend the adverse employment action against employees of ages 40 or over, an employer must be able to demonstrate a business necessity for doing so. To establish, again, a prima facie case of age discrimination with respect to termination, an individual must show that he or she has been in a protected age group, which is usually 40 years of age or over. She is doing satisfactory work. That's why those work evaluations are very important. Don't just give everyone a 3 or a 4 and just pass them through because you don't want to mess with it. She is being discharged despite satisfactory work performance. The position was filled by a person younger than the person replaced, and the key is to base employment decision on ability and not age. Let's see here. Some things we talk about: the English-only rules of national origin discrimination. We look at overqualified job applicants. An appeals court has ruled that the rejection of an older worker because he or she is overqualified may be a pretext to mask the real reasons for rejection, the employee's age. Got to be careful for that. Seniority. We talked about this a little briefly earlier, but the seniority system is a scheme that alone or in tandem with non-seniority criteria allots to employees ever-improving employment rights and benefits as their relative lengths of pertinent employment increase. Employers often work hard to hire and promote members of a protected group. If layoffs become necessary, however, these individuals may be lost because of their low seniority. The Supreme Court has ruled that an employer may not protect the jobs of recently hired African American employees at the expense of whites who have more seniority. We talked about testing and interviewing. Title VII clearly sanctions the use of professionally developed ability skills. All right, and Griggs v. Duke Power Company was a significant case because Duke was prohibited from requiring a high school education or the passing of an intelligence test as a condition of employment or job transfer because it did not show that either standard was significantly related to job performance. This meant that you can't have a test to weed out people for the sake of weeding them out. It has to be relevant to the job they're either going to be hired for or the promotion that stands ahead of them. If you have some kind of test or rubric, that's great, but it has to be relative to what they're going into You can't just have it to basically toss people out because you don't like them. Now, the rule included 4 general principles. The law prohibits that not only open and deliberate discrimination, but also practices that they're fair, informed, but discriminatory in operation. The employer bears the burden of proof that any requirement for employment is related to job performance. It is not necessary for the plaintiff to prove that the discrimination was intentional and that job-related and other employment selection procedures were legal and useful. Okay, let's see what we got here. Other things you guys need to be aware of is the term reverse discrimination. Basically, reverse discrimination is just as unacceptable as discrimination by whites against members of a protected class. It is illegal to use a disguised quota system such as numerically based preferential programs. The Supreme Court recognized that arguments from leading businesses, educational institutions, and military officials that a culturally diverse, well-educated workforce is vital to the competitiveness of the U.S. economy and the national security. To be consistent with the constitutional guarantee of equal treatment for all that fall under the law, race-conscious admissions must be limited in time. The Supreme Court emphasized that diversity is a compelling state interest, but that universities may not use quotas from members of racial or ethnic groups or put them on separate admission tracks. If you guys remember, about a year or two ago, we had a candidate at the University of Texas that tried to get in as a freshman, had higher scores, for all intents and practical purposes was a brighter student, and they dismissed him and took somebody from a different ethnic group. The case is still being decided, but that would fall under this category. Alright, so as you guys wrap up this chapter, like I said, there's a lot, but this is the nuts and bolts of HR right here. Try to look at the impact of the legal factors on productivity, quality for work life, and the bottom line with everything we've talked about. Review the retaliation, all right, how it works, the anti-retaliation measures and laws. And I want you guys just to basically get to know these key terms. All right, there's a lot in here, but really this is the nuts and bolts of everything we're talking about. So what I'm going to do now, I've taken about 57 minutes of your life. I'm going to conclude here. I'm going to encourage you to engage in the discussion question. And again, with the discussion, remember, I need you to answer the first question in detail, usually 150, 200 words, then respond to 2 other posts to get full credit. All right, I'm going to make a note of that on the blackboard in just a little bit. So you guys enjoy this chapter. If there's any questions, be sure to get a hold of me. Email or call me. Either way is fine. I'll be around all week. And you guys have a good week. Slowly digest this stuff. Go back and read it. Take your quiz after you feel like you're comfortable with it and engage in the discussion question. I'll talk to you later in the week, okay? You guys have a great holiday. Bye.